Let's take a look at an introduction to accountability. Accountability requires that we keep government open to public observation. To maintain a free society, citizens should be aware of what their government is doing, plans on doing, and has done. We must examine the public's rights to obtain information from the government and to observe its operation. The discussion begins with the Freedom of Information Act, the primary tool for obtaining information in the United States. Ironically, a discussion of the rights of the public would be incomplete without a discussion of the Privacy Act, a law that prevents governmental disclosure of information in special circumstances. Be aware that all states have government in the Sunshine Laws as well. Before 1966, little public right to inspect government records or to observe government hearings existed. This changed with the passage of the Freedom of Information Act, known as FOIA, in 1966. Today, the FOIA has been added to the APA section of the United States Code. There have been several changes to the FOIA, the most recent occurring through the FOIA Improvement Act of 2016. The FOIA's purpose is to make information held by the government available to the public. Be aware that each state has its own open government laws. They vary considerably in what records can be obtained, by whom, and what meetings must be public. The volume of requirements for information under the FOIA is staggering. In 2011 alone, 644,165 requests were submitted. The Department of Homeland Security received the greater number, 27% of the total. In some instances, agencies are required to publish specific information in the Federal Register. Parties dealing with an agency are not bound, nor may they be adversely affected by any information or rule for which the publication requirement was not met unless the party receives actual and timely notice of the information or rule. The second form of disclosure entails making information available for public inspection and copying. The first two requirements direct agencies to take affirmative steps towards disclosure before any request is made. The FOIA allows agencies to charge fees for responding to requests in some instances. The FOIA contains 9 exemptions. These exemptions are exclusive, that is, no others exist. The FOIA specifically provides for judicial review. A civil action to enforce a right to disclose under the Act must be brought in a federal district court. Congress requires that each agency submit a yearly report. The report is then referred to the appropriate committee. The antithesis of the FOIA is the Privacy Act. The purpose of FOIA is to make governmental records available to the public. The purpose of the Privacy Act is to withhold sensitive documents from public disclosure. The Privacy Act is also found in the APA, entitled Records Maintained on Individuals. This reflects the Act's goal of protecting the privacy of records collected and maintained about individuals, not other governmental records. Records are defined as any item, collection, or grouping of information about an individual that is maintained by an agency. The heads of some agencies may promulgate rules exempting certain records from the requirements of the Privacy Act. The Privacy Act does not prohibit agencies from collecting information about people. It does, however, restrict an agency's authority to collect information. An agency must maintain all records that it uses in making any determination about an individual with such accuracy, relevance, timeliness, and completeness as is reasonably necessary to ensure fairness to the individual. On request, individuals must be given access to their records or to information about them contained in an agency's record. Individuals must be given the opportunity to review and copy these records. Individuals may bring a person of their own choosing when reviewing the record. Individuals are also permitted to request amendment of their records if the records contain inaccurate, irrelevant, untimely, or incomplete information. The Privacy Act also contains both civil and criminal provisions. The reporting requirements are different for the Privacy Act than for the FOIA. There are 2 requirements. First, each agency must provide notice to Congress and the Office of Management and Budget of any proposal. Second, the President is required to submit annually to the Speaker of the House of Representatives and the President of the Senate a report on all agency systems of record. This report is to include explanation of exemptions. While it's the most significant in scope, the Privacy Act isn't the only federal privacy statute. A fundamental tenet of democracy is openness of government. The more open and available the government is, the greater the public's confidence and participation in government will be. This is the foundation of FOIA. It's also the basis of the government in the Sunshine Act, which generally requires that agency meetings be open to public observation. The Act applies to only collegial agencies, that is, agencies that are headed by more than one person. There's no requirement that a single agency head make his or her deliberations public. Agencies do not have to conduct open meetings if such meetings will result in the disclosure of specific types of information. The matters exempted are similar to those exempted from coverage of the FOIA. In fact, many are identical. The district courts of the United States are vested with the jurisdiction to review claims brought under the Sunshine Act. Venue lies in the district in which the agency meeting is held, in the district where the agency has its headquarters, or in the District of Columbia. Every agency must report to Congress annually a tabulation of the total number of public agencies, the number of closed meetings, the reasons for those closed meetings, and all related litigation must be included in that report. The government in the Sunshine Act requires that agency meetings be conducted in public. A number of advisory committees in the federal government are not administrative and not included in the Sunshine Act. The drafters of the APA and FOIA did not foresee the privatization revolution that would besiege government. Thus, the drafters did not make it clear whether the FOIA is to be applied to the myriad of private parties that provide services to and receive funding from the federal government. Clearly, the accountability objective of the FOIA can be undermined if private parties performing government functions are exempted from FOIA. This is especially troubling when governments contract services that have traditionally been considered core government functions, such as operating prisons. However, little public good is served by opening the laboratory records of a lone researcher who receives a small federal research grant and whose research could be threatened by premature public disclosure. The statute defines agency as any executive department, military department, government corporation, government-controlled corporation, or other establishment in the executive branch of the government. Public access to information in government meetings is important to governmental accountability.